The topic is the Brown versus the Board of Education decision in Topeka, Kansas, 1954. And we have with us our guest, Attorney Julian Blackshear. Attorney Blackshear, before we so abruptly interrupted you the last time, let's give you an opportunity to talk about the decision that was important in terms of the separation of the races, quote unquote, the Plessy decision. Let's start, give you an opportunity to do that.
Before I talk about that, let me put it in perspective. What I was about to say is the Supreme Court as an institution is not separate and apart from the political system. It's a third branch of federal government. It is an extension of the political system. And it's the whole basis of the Constitution of the United States as prepared and drafted by the founders of this country is that it must be drafted in such broad-based, generalized language that is capable of being interpreted and reinterpreted as society needs for it to say at the time. That's why the Constitution is always a living document. So within that context, the Supreme Court interpreted the Constitution in a manner in which society needed for it to say at the time that it was called upon to say it. So in 1896, 31 years after the Civil War, Supreme Court trying to maintain the integrity of the 14th Amendment that required no discrimination of the races, but at the same time understanding the social chaotic situation that existed at the time, 31 years after the Civil War, said that it's all right to separate the races so long as the facilities that the government provides to both of them are substantially equal. Hopefully that would satisfy the 14th Amendment requirement. Now in 1954, now the Supreme Court in Brown versus Board of Education completely overruled that. Now you need to understand, the Supreme Court in 1954 was trying to interpret the rights of the same black people under the same 14th Amendment. Then no I was undotted, no T was uncrossed. In 1896, it said that it's all right to segregate the races so long as the facilities provided to both of them are substantially equal. But this time in 1954, interpreting the same rights of the same people under the same amendment, make a 360-degree turn and said, no, no, no. You now must have integration in order for the 14th Amendment's requirements of no discrimination on the part of the government are satisfied. So you see that what has happened, in 1954, society had changed. It had changed to such a degree that the Supreme Court had to make that Constitution say what society needed for it to say at the time that it was saying it. And that's the reason why you got an entirely different interpretation of the same amendment regarding the same rights of the same people in 54 than what you had in 1896.
Now, in looking at that decision in 1954, and I think you said earlier that that decision was based upon several earlier decisions that eventually overturned it. Talk about the individuals who were involved in terms of the part that they played.
All right. Charlie Houston was the dean of Howard University Law School at the time, and he was the mentor of Thurgood Marshall, a young lawyer, general counsel of the NAACP Legal Defense Fund. And the theory